Okay. I've had an opportunity to take a look at the and consider the motion to suppress statements of defendant DeMontre Kendrick, and also to take a look at the state's response in respect to those particular assertions in terms of the for a Jackson Daniel hearing, which the court has to make those determinations of voluntariness thereof.
I'm sorry.
What was the last thing you heard, Christina?
Application in terms of the Jackson Daniel hearing, which
the court has to take into account to determine the voluntariness of statement. In such, I have considered as well, and will be admitted for purposes of the motion to suppress, Jackson Daniel hearing states 1 and 2, Mr. Kendrick's video statements. In particular, the court has viewed a portion of those particular statements relative to the periods of time at 2:16 p.m. continuing for approximately 3 minutes or thereabouts. Also from 2:56 p.m. continuing to about 2 or 3 minutes. And the court specifically has heard in the first video at 2:16 or thereabouts, near the end of that colloquy with the detectives, I need to talk to my lawyer. I don't want to talk no more. And at the second video, starts at 2:56 p.m., goes for about 2 to 3 minutes or thereabouts, and stops at 2:58 and 53 seconds.
Your Honor, may I address the court?
No, I want to make my ruling, okay?
I haven't presented any evidence.
I can take this on argument, and that's what I'm going to do. I'm going to, in terms of the what's been admitted for the court's consideration, that particular portion of the video is what I need to focus on. What I need to focus on is whether or not Mr. Kendrick was in custody, whether or not Miranda was appropriate at that point in time, and whether or not he invoked his right to counsel.
And whether he reinitiated it.
Yes.
We have the officer to talk about that.
I don't need that at this point in time. I really don't. I'm of the opinion. I also had a chance to take a look at Mr. Uhelski sent me as well, and I'm sure the other counsel got a copy of the United States versus Kendrick, both the district court order, which was a hearing in front of Judge Alan Baberman, the United States magistrate, and then Judge Mark Cohen, United States District Court judge. And then the appellate opinion was an opinion based on sentencing. Mr. Kendrick appealed the severity of his sentence. So I'm taking a look at the appellate order, at the trial court order from Judge Cohen, adopting Judge Baberman's findings.
Right.
And I make it very, of page 2. During the course of page 2, during the course of over 2 hours of the initial interview, defendant did not ask to speak to an attorney. At some point during the interview, Detective Joe Galpin, who was investigating a separate homicide incident, entered the room. Defendant then indicated he wanted to talk with his attorney, and questioning stopped. So Judge Baberman, I can't tell whether or not he took into account what I heard on the video, which was, I need to talk to my lawyer. I don't want to talk no more. That is equivocal to this court, me, Judge Glanville, that he invoked his or withdrew his consent at that point in time and did not wish to speak to law enforcement officers anymore. I understand the state's argument about parsing it out, asking for clarification, but I think that once he's the appellate, case law that I've looked at, in Paldo, and others, he has invoked his right at that point in time, and it's this court's opinion that anything thereafter would be inadmissible.
Your Honor, the court also found that he reinitiated, and that was what.
But that's their issue. That's not my issue.
Your Honor, I'm not.
Okay, and to your point earlier, Judge Cohen and Judge Baberman, I can't tell whether or not they listened to what I heard, but you're only as good as the information that you're given.
Right.
So it doesn't say on this particular order that that's what they relied upon. It just says he wished to talk, some point in time, he wanted to speak to his attorney. Now, I'm of the opinion, this court's of the opinion that questioning needs to stop. He's unequivocally revoked. And you can't pick and choose at this point in time whether or not it's to this particular crime or any other assertion. So that's why I'm going to suppress it.
And Your Honor, Your Honor, with respect to the statements that were made after that time, we do have, as I stated, Investigator Thorpe to tell the court on the record, present under oath, that it was not Detective Thorpe. It was the defendant that reinitiated the conversation with Detective Thorpe. Our representations to the court are not evidence, and since the state has the burden of proof.
Okay, but I've seen the video at this point in time.
The video does not encompass when the defendant actually reinitiated contact.
But the problem is, he invokes, and then we don't know what goes on in the 45 minutes, but we come back afterwards, and at that point in time, you don't get to eat your cake, have your cake and eat it too. It's once he invokes, that's it. It's over.
Your Honor,
they should not be bringing him back at that point in time and asking, well, let me just clarify a little bit about whether or not these statements were made to these set of detectives or to Galpin.
It wasn't there in the room that I'm talking about, Your Honor. I'm talking about in the first, the defendant asked for a smoke. So they took him out for a smoke. When they took him out for a smoke, the defendant reinitiated the conversation as they went outside. That is what they found in the district court, but the court doesn't owe that deference. That is why we have, as the burden of proof, holding the burden of proof, that is the reason we have Detective Thorpe here to testify.
I don't need his, I'll consider it, but it's this court's opinion that once he invokes, you don't get another bite of the apple by taking him outside, softening him up, giving him a cigarette, some bonbons or whatever, and then letting him go ahead and then say, oh, well, let me just clarify with you a little bit. That's not how that this scenario worked. I think that you all are just annoyed more so that your detective did something that he probably regrets now. And that you all probably would not have told him to do. Don't interrupt this particular investigation or this particular hearing, because what you did is you just now created a wrinkle that now I got to deal with, or whether or not the defendant has invoked his right to counsel. He has.
And Your Honor, I'm not annoyed, Your Honor. I just have, with the burden of proof, we have a person who can speak to the issue rather than having us, sort of speculate as to what happened, because it's not, as the court at this time has indicated that it sees, which is that we softened him up with things. That's
my ruling. And prepare an order suitable on my directives,
Yes, Your Honor. Thank you.
Mr.
Your Honor, we have not presented any evidence regarding what happened in the Sally Port. Would the court permit the state to present evidence of what happened when they went upon the defendant's request to get a cigarette?
Ms. Love, I'm of the opinion it's not going to change my mind at this point in time in terms of, because he's invoked, anything after that would be improper. It really would be, because it'd be one thing if he said, well, maybe should I get a lawyer? Maybe should I do whatever this, or, vacillate. But he's pretty significant in the sense of, I need to talk to my lawyer. I don't want to talk to no one.
And Your Honor, our case law shows that even when that happens, when the defendant reinitiates the conversation and communication, that the court has found that those statements made after the defendant reinitiates conversation, as unequivocal as his initial assertion was, when the defendant reinitiates the conversation, the statements that he makes are not to be suppressed. And in this case, the defendant reinitiated the conversation, not the officers. And Your Honor, we've provided to the court, and we have proof. We have actual testimony, given that we do have the burden of proof. Your Honor, Munn versus the state, 313, Georgia 716, says that the court must consider the totality of the circumstances and determine the admissibility of the evidence of the statement under the preponderance of the evidence standard. And Your Honor, given the fact that we have a witness here to testify, the court doesn't have to take my word for it or Mr. Weinstein's word for it. We have the person who was there. The court gets to gauge Detective Thorpe's credibility, and the court then has substantive information and evidence upon which to base a ruling under the actual totality of the circumstances. Right now, we have a clip. When I asked Mr. Weinstein to play for the court the portion to which he objected, that wasn't the state conceding that we weren't going to put up evidence, Your Honor. I was trying for the sake of brevity to have him point out the part that he objected to, but then that left us without the ability to present anything. And we weren't stopping there. We were just showing to the court where he was arguing the points that he made to us that he wanted to contest. So we would like to present actual evidence to show under a totality of the circumstances.
I got the evidence. It's been admitted. The two videotapes are sufficient for the court's analysis at this point in time. So
that's your ruling. Thank you. I have nothing to add, Your Honor.
Right.
And Your Honor, what happened with the Sallyport, the conversation being reinitiated by the defendant, that actually happened, and we have the proof here to show it to the court.
Well, based upon what you've argued so far, and that in this particular circumstance, this court's of the opinion that it's like this. Once you initiate your right, or you revoke your right to be examined and have counsel and to have counsel present at that point in time, the courts are very, let's just say, cautious about reinitiation at that point in time. And at that, you all presented to me what was the salient point of this particular issue is. So if I believe at this point in time that he's invoked unequivocally his right to counsel at this point in time, the questioning is supposed to stop. You're not supposed to go out and get cigarettes and do everything else. It's supposed to stop. I mean, that's this court's opinion. So, and that's my ruling.
And Your Honor, the thing is that, Your Honor, we did not.
You're arguing with me now, Ms. Love. So can we stop at this point in time?
Your Honor,
if you have other evidence independent of this, I'll consider it at the appropriate time.
And we do, and that is what I was asking. So if the court will permit me to actually introduce the evidence that we have, as the court in State versus Paldo 309 Georgia 130, where it says a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning until the suspect reinitiates the conversation. And in that, they are citing Dozier versus the State 306 Georgia at 35. Your Honor, Edwards versus Arizona. And Your Honor, this is a 2020 Georgia Supreme Court case where it specifically says that a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning, as the court has said, by law enforcement until an attorney has been made available or until the suspect reinitiates the conversation.
Your Honor, at some point, Your Honor,
I'm sorry, I'm talking, and I don't know why I am being interrupted. I will not stop.
Hey.
I was speaking.
Ms. Lowe, y'all got.
I'm sorry, I was speaking.
Both y'all can't talk at the same time.
I know, I was speaking, and I expect you allowed to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
and I know you're being an advocate, but at some point, stop. Just stop. I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept that fact.
Okay, no, you don't. No, you don't.
Your Honor, we have just not been able to present the evidence.
No, you don't. I get it. I get it. And if you have an independent basis to introduce statements that may not, or that may be not subject to the fruit of the poisonous tree or any other thing or any other issue related to evidence that may have flown out of this particular interview, then I'll hear it at that point in time.
When the court says independent basis, does the court mean outside of that video? Because we do have that.
Yeah, if it's not tied to the statement, of course you can introduce it.
Yeah.
I mean, as long as you have some independent basis, right? If you didn't get it from his particular statement.
But Your Honor, that's the point, that we have the witness here, that we brought the witness here, and had him cancel medical appointments to testify to the court about. We brought the witness here.
I made a ruling. That has nothing to do with it. That's a red herring and you know it.
No, Your Honor, I was saying that we were ready to present evidence and the court is not allowing us to present the evidence. That's all that I'm saying. We have the burden of proof and we haven't even been able to present the evidence that we have. We only, for the sake of ease, allowed the court to introduce the statements that the defendant made as states 1 and 2 to help Mr. Weinstein play the portion that he wanted to talk about. We didn't even get a chance to play or to have the evidence that the state has ready for presentation to the court to be presented. We should be entitled to present the evidence so that the court actually has the circumstances and does not have speculation or conjecture as to what happened when the Georgia Supreme Court has clearly said, just as clearly as an attorney being present is required before you consider the statement once he's invoked, the court has as clearly said, if he reinitiates, then that statement can be considered. It does not use them like maybe. It says, if this or that, then the statement can be considered, unless it should be suppressed for another reason. And that case, Paul Doe, is as recent as 4 years ago. And I'm not just doing this for the sake of engaging in a pattern of behavior, Your Honor. I am standing here emphatically asking that the court allow the state to present its evidence so that the court can make a ruling based on the evidence and not on the assertion by one party or the other as to what should or could be done. We have evidence that I believe that the state is entitled to present and the court is entitled to hear in the form of testimony. And I understand that Mr. Weinstein wants us to hurry it along and not hear Detective Thorpe because that might be an adverse position or evidence to his client's position. But we are simply asking that the court allow us the opportunity to present the evidence and to not hold it against the state that I am asking this, that the court allow us to present evidence that this statement was made voluntarily and that the fact that he ceased it but then reinitiated it is something that the court should consider. And Your Honor, I don't like drawing the court's ire. It's, quite disturbing. But I cannot in good faith not present evidence when we have a whole burden of proof to show the court that it was made freely and voluntarily. And when the evidence that we have is sitting right outside the courtroom. And the court's whole purpose for having these hearings is to determine the truth and to decide what is fair. And without hearing from Detective Thorpe, I don't know how the court can discern what the truth of the matter is. Hearing only a portion of a recording and not hearing from the people who were actually standing there talking to and listening to the defendant. Unless without hearing Detective Thorpe, the court is making a credibility judgment before even hearing what he has to say.
May I please speak? Please, may I please speak?
Okay.
And Your Honor,
Are you finished, madam?
I was not, Your Honor. I was
Your
really
Honor,
not.
Hold up. You got 30 more seconds. Wrap it up.
And Your Honor, I'd ask again the court for the opportunities for the state to be able to present evidence so that the state can meet its burden and not have the court make any kind of ruling based on really partial pieces when the court does not have a totality of the circumstances as a part of the record for the court to consider. So I would ask the court in earnest to allow us to at least present the testimony of Detective Thorpe. If not today, I don't mind doing it. I said in my email to the court and to counsel that we can do this closer in time because he does have or did have that appointment closer in time to when this matter will be right. But Your Honor, I implore the court to allow us to actually present the evidence that we have to present. I appreciate Your Honor giving me the moment to speak. Thank you.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop so that opposing counsel can speak. Your rulings at some point have got to be final, Your Honor. Whether you hear from Detective Thorpe or not is irrelevant. He requested his lawyer. He invoked his right to not speak anymore. And I don't care what schmoozing Detective Thorpe did out at the Sally Port, taking my client off camera. I don't know what went on down there. I don't know what well, I have some idea. I don't know what self-serving statement Detective Thorpe could possibly give to this court that would cause the court to change their order. This continued going back whenever the state loses in this case has got to stop at some point, Your Honor. Thank you.
All right. So we were talking about Mr. Bean, and there's a detention facility that's actually at Grady Hospital, correct?
There he is.
All right. Is that what Mr. Steele was referring to, or could it be that he's referring to that?
Your Honor, this is the issue that I have with what Mr. Steele is doing, and this is what 24-1-103 prohibits. Specifically, 24-1-103, as the court is aware, states that jury proceedings shall be conducted to the extent practicable so as to present inadmissible evidence from being suggested to the jury by any means, including but not limited to making statements or offers of proof or asking questions in the hearing of the jury. So when the state has been making the objection that the questions Mr. Steele is putting upon the witness assumes facts that are not in evidence, Mr. Steele has responded by saying he has a good faith basis, but instead what he is
the court
doing,
asked him that, and he can ask the question if he has a good faith basis, meaning that he cannot misrepresent or lie to the court about Mr. Bean's whereabouts. So I wanted to make sure that was kind of not occurring. So I understand what a 103 analysis or inquiry allows the court to do. So is it your opinion? I just want to ask you a question. Sorry to hijack you again. Is it your opinion that the conversation about Grady is not appropriate because it was at Grady detention or in the hospital?
No, my assertion is that Mr. Steele's questions go something like this. Why did you tell Detective Lewis at the hospital that you were not driving? He also
is that
asked,
Grady detention though?
Yes.
Okay.
But wait a minute, Your Honor. This is just it. His question, why did you do that, assumes that the witness did that. And there is no evidence that the witness did that.
Well, it needs to be rephrased.
And Your Honor, he also 28 times has asked, when you talk to your wife on an unrecorded line at Grady Hospital, there's no evidence that he did that. There's no evidence that will come in, and there's no evidence that Mr. Steele can bring to the court. And if he does, I would ask that he proffer it, because I listened to the information, to the recording that Mr. Steele gave us at 6 o'clock that day that he presented that he cross-examined Mr. Bean. And he asked a plethora of questions that are nowhere in that recording. And he is doing it on the basis that he is confronting him with his prior statements. But the problem that I have is this. In that recording, Mr. Steele references prior conversations that he has had with Mr. Bean. So in an effort to discern what he's talking about or what information Mr. Steele may have fed Mr. Bean or what happened, I asked the witness, who is also on the recording, I called him up and said, I'm trying to find out how many times you all talked to Mr. Bean, what did you say, and whether there were any other recordings. The witness, Mr. Steele's investigator, told me, I'm not comfortable talking to you without Mr. Steele. I won't talk to you without Mr. Steele. As a matter of fact, no, you may not call him while we're on the phone. I don't want to hang up on you, but I will. And this goes to privilege. I said, I'm just trying to discern how many times you all talked to Adrian Bean so that I can have information that I'm entitled to. He would not give me any information. So I called Mr. Steele. Mr. Steele didn't answer. So I wrote Mr. Steele asking for how many times you talked to Adrian Bean. Give me the other recordings. Give me what you have. He did not respond. I called Mr. Steele. I said, Mr. Steele, how many times did you talk to Adrian Bean? He tells me, I'm not going to answer that. What you're doing is somehow unethical, and we'll take it up with the court in the morning. I said, okay. So, Your Honor, the problem that I have is, one, Mr. Steele is improperly suggesting to the jury, planting in the jury's mind that this witness made certain statements to the police at the hospital when he did not. Mr. Steele doesn't have any evidence whatsoever, any statement. He doesn't have any recording. He doesn't have anything. He has not asked the witness. He has not done anything to present a statement at the hospital by this witness, and certainly not one to Detective Tracy Lewis. So Mr. Steele tells the court that his good faith basis for asking the questions that he is asking is that he is confronting the witness with the statements that he made during the recording that Mr. Steele provided the state on last Monday. When in fact, the information that he is asking, he is not saying, did you talk to Detective Lewis, or you talked to Detective Lewis, didn't you? Instead, he's saying, why, when you talked to Detective Lewis, did X, Y, and Z occur? And that in itself is exactly what this rule is designed to prevent, Your Honor. Because unlike asking the question, it's sort of like asking, did you mean to beat up your wife when you hit her in the head? When there's no evidence that the wife was hit in the head or that the person on the stand actually did it. So under 24-1-103, 24-6-6-11, 24-6-6-23, the state would ask that all of these impermissible questions be stricken and not allowed. So when he is asking these 28 times, why did you do this? Why did you do that? Unless and until he can show in his recording to the court where the witness told him those things that he is saying to the jury the witness said, then I would ask that the court prohibit him from referring to anything of the sort that did not occur.
Okay.
And I would ask that we can go back over it at a later time. For now, I would simply ask that the court prohibit Mr. Steele from presenting to the jury things that he knows aren't in evidence and will not come in evidence. And I would ask that the court require Mr. Steele to turn over to the state if he has some more recordings, or at least tell the court and the state how many times he's talked to the witness, because in a state where we are not only providing to defense counsel unwritten statements that we have or unwritten conversations, we're providing them summaries of conversations. We're turning over at the court's direction information that they normally would not be entitled to. At the very least, if they talked to Adrian Bean a number of times, and to be clear, what Adrian Bean did in the interview with Mr. Steele, in my opinion, Mr. Steele's suggestion is recant and say things wholly favorable to Jeffery Williams. And Mr. Steele, I guess, doesn't want it to look like he is, Mr. Bean is trying to favor his client. But I ask that the court listen to that 10-minute conversation that Mr. Steele had with Mr. Bean, and then the court will understand why the state is objecting to Mr. Steele's questions. Why did you do this when you gave your statement to the police at the hospital? He knows that Mr. Bean said in his interview with Detective Quinn, when I talked to the first guy, I said X. That was on scene. That was on scene. And Mr. Steele knows that. He knows there's no suggestion that that happened at a hospital. Mr. Bean was transported to the hospital. We have him with Detective Faust, who was there, who arrested him and took him to Fulton County Jail shortly after. The CAD reports show that he was transported to the hospital around 1, and he was taken back to the jail and booked in around 6 o'clock in the evening. And there is Detective Quinn is still on site at the scene during that time. Detective Lewis during that time has gone and spoken only to, I believe it was, to Walter Murphy, only to Walter Murphy. She documented it. She documented what Walter Murphy said. Detective Calhoun went and spoke with Frederick Prothro, documented it, documented what he said.
So nobody had a conversation with Mr. Bean at Grady?
Correct. And if Mr. Steele wants to say he did, it is his burden once the state has asked the court to determine that so that we can get this issue resolved. He has to show where this statement is. And to sit there and ask for something from the state that he knows there's no record it even exists is disingenuous at the least.
Okay. All right.
So I'm asking that the court disallow these questions that begin with, did you know that? Why, when you talked to so-and-so at the hospital, did you do this? Why did you, when you talked to your wife on an unrecorded line at the hospital, there's no such evidence, nothing like that even exists. It's fabricated evidence. He is trying to fabricate evidence to confuse and mislead the jury so that when the jury hears his question, they already have in his mind, oh, there's an interview at the hospital. Where is it? Why haven't we presented it? Why didn't the state present it? I have no doubt at the end they come up with this. The state didn't show you the interview at the hospital when one doesn't exist. So I would ask that Mr. Steele be required, one, to turn over any kind of information that he has to the contrary, provide to the state any conversations, any interviews he has done with Adrian Bean. I don't know what happened during those interviews, and I don't know what his investigator said to him. I don't know what was promised to Adrian Bean. We have no way to know that because neither Mr. Steele nor his investigator will divulge that information. And Mr. Steele has yet to show he's, one, improperly, again, putting untrue assertions in front of the jury with his questions, and two, has not provided the court anything to show that what he is suggesting to the jury exists actually exists.
Would they be required under the reciprocal discovery statute?
Well, in order to impeach a witness with an inconsistent statement, the party that is using the statement has the obligation to afford the attorney, the other side, to the opportunity to question the witness on those statements. So, yes, we are supposed to have those statements, and we don't have them. And the questions that Mr. Steele is putting on this witness go way outside of the boundaries of this 10-minute conversation, this clip of a recording that he has.
Okay, all right. I'll hear from Mr. Steele. All right, sir.
Good afternoon, Your Honor.
Good afternoon, sir.
Good afternoon, everyone.
Can I ask you the $64,000 question, Mr. Steele, to begin with?
Sure.
Is there an interview of Mr. Bean at the hospital or Grady detention facility?
Yes, that's what he told me.
Okay, can I see it?
That's what I've been asking for.
No. Do you have it? Do you have one?
No, I've been asking for.
Well, okay. Here's our challenge. Unless you know there's one and the state's told you they don't have one, then you don't really have a good faith basis to ask that question.
Mr. Bean told me.
But now there has come to light that Mr. Bean he's at Grady. He's in Grady detention, but he hasn't made a statement to anybody else, any law enforcement officers.
Let me take you back, because that's not the way I understand it.
Well, did he interview? Did he have discussions with Detective Faust or Detective Lewis at Grady?
I can't tell you which detective. I can tell you that that is what he said, and it's backed up.
By whom?
I'm going to show you, if I may.
Your Honor, when we play the recording, it takes 10 minutes.
Of Mr. Steele's investigator?
Yes.
Sure, we can hear it, but let me hear from Mr. Steele first.
Okay. So what happens here, Your Honor, is the last time we were together on March 4th, 2024, the district attorney stopped the cross-examination, approached the bench, and the following occurred. This is an excerpt portion. I'll mark it as Mr. Williams, number. Number B, dated today. And what happened is the state, just like it's doing now, accused me of the following. And this is just the context, and then it will get into exactly what you're asking. It's on page 2, Your Honor. District Attorney Love stated, starting at line 13, that I told the witness what to say, that Mr. Bean was never taken to Grady Hospital. From transfer page 2 to 3, District Attorney Love said Mr. Bean was never interviewed at Grady Hospital. Transfer page 3, lines 3 through 4 and 8 and 9, Mr. Bean went straight from the scene of his arrest to the Fulton County Jail. Page 3, line 18, when this honorable court asked the question, did he, meaning Mr. Bean, go to Grady? Ms. Love stated, and I quote, no, he, meaning Mr. Bean, did not go to Grady. Mr. Steele told you about whatever he's trying to do. You asked me, did he go to Grady? I said, that's what he's saying, or some hospital, yes. Page 3, line 18. 20 to 22. On page 4 through 5 of the same transcript, I asked.
I have the transcript.
Okay. I asked in lines, it's transcript 4 through 5. I asked for Mr. Bean's statements to police. And he said, this way I understand it, is Jeffery Williams was not in the vehicle, or he didn't mention him in the vehicle. He put 3 people in the vehicle, and he lied about who was the driver of the vehicle. And I said, it's Brady evidence, I'm entitled to it. Transfer page 5, lines 20. Starting in line 20 through transfer page 6. District Attorney Love answered your question. Nothing shows that Mr. Bean went to the hospital. District Attorney Love on transfer page 5, line 24 through 25. Mr. Steele is misrepresenting that to the court, meaning that he was taken to the hospital. Transfer page 6, lines 1 through 5. District Attorney Love states Mr. Bean went straight to jail and that the district attorney has the documentation, the printout. I asked to see it. I was never shown it because I didn't believe it to be true. And I'm going to tell you why I believed it wasn't true. To answer your question fully. Transcript line 7, page 4 through 5. I have no good faith basis to ask this question. Ask this question is my words. Transcript page 7, lines 6 through 9. District Attorney Love said that I have nothing of either Detective Quinn saying on recording, hey, he went to the hospital. District Attorney Love stated to this honorable court, continuing to tell you that I misrepresented intentionally. Page 7, lines 10 through 24, that I assume things, nothing on the tape. Mr. Steele, this is a quote, put that in there, end quote. Mr. Steele knows it did not happen. Mr. Steele is manufacturing evidence. On page 10, you advised us on line 20 through 25, the issue is whether Mr. Bean was taken to the hospital, whether Mr. Bean made a statement at the hospital, and on transfer page 11, lines 9 through 10, District Attorney Love, again, Adrian Bean never went to the hospital. So I knew that that was all wrong. But, you know, when a lawyer says something like that, maybe my information is wrong. I'd like to see the documentation. I don't get anything. So, Your Honor, and it's in evidence. If it's not, I'd like to put it in evidence. The reason I believe that he went to the jail, not straight to the jail as being told to you, is that in discovery, the following occurs. And I'll mark this as Mr. Williams' exhibit number 202 with the court's permission. It can be played for the court. This is the file. It was given in discovery by the state of Georgia to Mr. Williams and all. This is the police radio traffic. You heard some of it during the trial through the witness who identified the radio traffic. It starts at 0054. This is Z radio, 1231 hours through 1300 hours, so 1231 through 1 o'clock. And it reads, down here on Cleveland Avenue, status of 4, that means ambulance, Your Honor, you heard that through the testimony. For a 34-year-old black male with injuries to his shoulders, head, and to his back. If you remember, Mr. Bean was born 6/22/1979, that would make him 34 years old on September 11th, 2013. It says, okay, Cleveland Avenue, Old Hayfield, 122, Cleveland, and that ends at 112. At 1300, Major, where do you want me to bring the bus? Meaning the ambulance. Oh, come up here to Cleveland and Old Hayfield. Take a right. I'm standing here. I'll direct you in. That's at 1314. At 1602, 2308. I'm still at Cleveland Avenue, Old Hayfield. I got a perp in the backseat of my car. That's at 1607. It ends. At 2808, 2308. I'm right in the parking lot. Tell him to come down Cleveland Avenue. I'll get him. I'm in the parking lot of the Coin Laundry. All right. Trying to get Grady to find you. Right. Then it says unintelligible for my notes. I'll get out of the car and flag him down. That's at 2028. Then at Mr. Williams, I'll mark it exhibit number 203, Your Honor, for purposes of this, or I'll play it for the jury. File Z radio. It's 1301 hours through 1330. So that's 1:01 in the afternoon to 1:30 in the afternoon. Same date, September 11, 2013, 1842. On the recording, 13 radio following Grady Unit 320 down to Grady Hospital, 1848. At 2736, are you en route with another victim? We en route with another suspect. The other suspect, okay, I copy that. He's 1050. Also, 1050 is a shot. Says, I don't think so. He's going to be in custody. He's in 83. 83 means another warrant. Mr. Bean at that time had a warrant for the year before for shooting 2 people. You heard that impeachment. He pled guilty to that. He received before the Honorable Judge Downs 15 to do 3. Okay, so why not bring him to Grady? So why not, bring him to Grady? Isn't he injured from the crash? He's probably going to be injured, Sarge. That's why they've taken him to Grady detention. So probably be injured. Okay, copy that. He was the guy that was hit by the car, ? I don't know which one the guy he is. This is the one that AC, meaning you heard from AC Booker Higgins, officer, and them got over at the Barber Institute. That is Mr. Bean, in fact. Yeah, that's affirmed at 2836. Then I'll mark it Mr. Williams, Exhibit 204. It's file Z radio. It's 1331 through 1400 hours, so it's now 1:30 to 2 o'clock. 2820, raise 2013 and have them go over. We got the 83, that's Mr. Bean, down here at Grady, and that's at 2827. So I knew he was at Grady when Miss Love was making these representations that I'm misrepresenting. But, you know, I don't find lawyers to do that. Then, Your Honor, there is a recording, and it's at 1949. We can play it for you. It's Detective Quinn and Mr. Bean. So it's 6 days later. So it's now the 17th of September, 2013. And Mr. Bean is being recorded the whole time by Detective Quinn. And Detective Quinn states as follows. Excuse me 1 second, Your Honor. At 44:56, actually.
In what, sir?
This is September 17, 2013, recorded interrogation, Detective David Quinn, now retired, with Mr. Bean. And I'll play it for you if you'd like, but Adrian Bean states as follows. Yes, sir. I lied to the detectives when they first came and talked to me. And I told them that's probably the lies that you're talking about. Detective Quinn then said, okay, what did you tell them? Adrian Bean, I told them Big Fred was driving. So we're sitting here. I have zero information on when Mr. Bean spoke with detectives. But I do know this. Mr. Bean told me that he spoke to detectives at the hospital. Detective Calhoun testified before the court, went down to the hospital, spoke with, it's on recording, Fred Prethrow. Fred Prethrow was asked, what happened? Who was in the car? Fred Prethrow said, DK, Adrian Bean, and me. 3 occupants. It's on recording. Detective Lewis goes and speaks with DK, who is known as Mr. Walter Murphy. I have no recording. I have
No recording of whom?
Detective Lewis at the hospital, Grady Hospital, September 11, 2013, meets with Walter Murphy. And Your Honor, as my eyes roll out of my head, I'm about to show you why I do not believe the City of Atlanta Police Department at all. This is served in discovery. I will mark it Mr. Williams C and D. And then you tell me if I'm supposed to believe the allegations from the state of Georgia.
And Your Honor, while Mr. Steele is pulling that up, I am reiterating that his failure to believe or not believe is not a good faith basis for asserting facts that are not in evidence.
Well, let him finish, and I can kind of have another conversation with y'all about it, okay?
Madam Pro Tem.
You may, sir.
For purposes of this motion, I am handing the court what I was provided in discovery by the state of Georgia. I made it for today's date, Ms. Williams, Exhibit C, as in Colette or Charlie, and D as in Delta. And if you will see and take note, on the top, it's the City of Atlanta Department Supplemental Incident Report, narrative only, page 1 of 1 on both C and D. Your Honor, the incident report is exactly the same, 13-254-1308. The complaint name in both are left out. The date of the report is the same, 9/17/13. It says reserved, and nothing's in there. It then has a narrative section with an affidavit. Your Honor, the first paragraph has Detective Lewis going to, the two people going to the hospital with injuries, Investigator Calhoun and myself. Investigator Lewis went to Grady Hospital. If you remember from the testimony, Investigator Calhoun goes and meets with Mr. Plethro, 3 people in the car. Investigator Lewis goes and meets with Mr. Murphy. Investigator Calhoun recorded it. I have this report on Investigator Lewis. Next paragraph of C and D are identical, Your Honor. Once we arrived at Grady Memorial Hospital, there were 2 males being brought in for gunshot wounds. I was advised by the Grady medical personnel they're not life-threatening. We could speak with them once they got stabilized. It's going to be identical. The next paragraph, Your Honor, the first 2 lines. The first line, I spoke with Walter Murphy in C, gives a date of birth, 8/9/91. He had sustained a gunshot wound to the left thigh. It's going to be identical. Then it starts, he advised that. In C is in Colette and Charlie, but in D, it says, he advised me during the. Then D is whited out. The entire part is now vacant. C goes on to say that the other 3 males, now there's 3 people in the car, one named Bean, drove to the laundromat on Cleveland Avenue to meet up with another male to sell an ounce of marijuana for $450, and it goes on. Your Honor, at the bottom of C, it is signed, same looking signature of Investigator Lewis, I presume, on 7, reporting officer's signature. It is also signed similar on D, Mr. Williams D. The APD number is written in on D, but it's typed in on C, and it's the same ID number, 3081. As far as section 9, which is in the center on the bottom, it says sworn to and subscribed before me, the 17th day of September 2013, in type on C. D, it's in writing. And then on the bottom, it says supervisor's signature, and a supervisor actually signed off on C, which is supposedly a complete report, as also D, which is clearly whited out. In addition to that, Your Honor, on both C and D, there is a statement at the very bottom, before the signature, above the signature line, the undersigned being duly sworn upon his or her oath deposes and states that the foregoing is true, correct, complete, and legible to the best of his or her knowledge and belief. So when I sit here and I hear Ms. Love tell me how diabolical I am, and how I don't have a recording, or I don't have a statement, or I don't have a note, or a summary, or a writing that Mr. Bean was interviewed at the jail, at the detention center after Ms. Love told this honorable court total misrepresentations. I don't know. I assume that she had a good faith belief, because that's just what I do with lawyers. But she attacks me like I'm out of my mind when this is in the discovery. This is all, she knows this. And then I'm giving C&D, which is clearly going to come out before your court, because if the state doesn't call the investigator, I'm calling Investigator Lewis. Because this is what I would say is corruption. Because I don't see this often.
Do we know why why one statement is incomplete and the other one is?
And why I have no recording. And why I only have this on the 17th day of September. And why Detective Calhoun's is all in recording and a report on that day. And why is it that Adrian Bean tells Detective Quinn, when I first spoke to the detectives, I lied to them about Fred Prethro driving? And why is Adrian Bean telling me, yeah, the police wanted young thug, Jeffery Williams, whatever the words are, involved in this case? And why is it that Adrian Bean is on a jail call with his wife? It's the next day. It's September 12th of 2013. And his wife says on that jail call, the homicide investigator, who's going to be Detective Quinn, came by a second time yesterday. That's the date of the incident. And he told me that the driver, people think the driver's a woman wearing a wig, but it's really a man. It's a boy. And Detective Quinn is giving this information. And whoever the driver's in big trouble, but if Mr. Bean is a passenger, he may not have any charges. And on that same recording, Adrian Bean is telling his wife, they gave us a story to tell. And Adrian Bean tells me, with Investigator Martin, that story to tell happened at the hospital. Now, he blames it on Detective Quinn. It's also 10 years before, so maybe it's not Detective Quinn. I'm not saying it's Detective Lewis. My questions were, or some detective. But his point is, it's a detective that introduced Jeffery Williams to this. And then you could go through the crime, which I'm going to do, the crime scene photographs. There's not room for 4 people in the back of the car. In addition, there's no shooting in that car. Like the police did it and they cleared, and I'm not saying Robertson L was not justified. I am not saying that. But Robinson L discharges firearm multiple times and it crashes through the very rear window on the passenger side of that 2004 Nissan. Those bullets go somewhere. Mr. Murphy is shot twice, one in the lower ankle in his right leg and one in his left leg, upper thigh, which strikes an artery. That's why there's so much blood from him. Fred Plethro is shot through the headrest. Now just imagine a 6'3" young man sitting in the ways of those bullets. They can't get around him. There is no one else in the car. And the state is blaming me for this. This is outrageous. And I can ask every single question the way I ask it, and I ask it properly. And Adrian Bean, for all that he's worth, the jury makes a determination. And what Ms. Love is trying to do is obstruct the truth from coming out, because she knows all this. That's why last time I was a fibber for telling the court that he went to Grady Hospital. When she realizes it's patently true, now I'm a fibber because no one spoke with him, and I'm just supposed to believe that these officers took him down and they had him on wraps and no one spoke with Adrian Bean. I apologize to the court. That's also a jury. Juries make those determinations. In addition to that, this case should be dismissed. This is outrageous. I'm going to do that once I get it into evidence before the court, but I'll do it now since it came up and Ms. Love is attacking me. And this evidence is wrong. I also ask continuously for all these videos. I don't get it. And then months later, I'm getting a video on the shooting at the movie theater, which I know you don't know about yet, but it's about Christmas of 2000, maybe 15. The point I'm trying to make to you, Your Honor, is this is a moving target by the state of Georgia. And no, to say that I have no good faith belief because I can't show this honorable court where these statements are, that's my point. It's Brady evidence. This is all Brady evidence. And if this happened in another forum, the state bar, I'm not doing that. I don't report people. I believe in people and lawyers. I don't know what Ms. Love is doing, but to attack me on misrepresenting to this honorable court, I have never done that. I will not do that. And I will never, ever do it to any court. That's not what we do. But I also understand my duty is to make this process rigorous, zealous, and I am going to fight for Jeffery Williams in every lawful and ethical manner the entire time. And that includes destroying Adrian Bean's testimony and revealing the truth. In addition to that, Your Honor, the state of Georgia calls our investigator and wants to know dates and how many times we supposedly met with Adrian Bean. That is work product. That is not a statement. That is not covered in any type of work product, and this is not my witness. So when you ask the court and you never got the answer, but OCGA section 17-6-4B as in Barry, Bravo. May I approach, Your Honor?
You may, sir.
Your Honor, this is 17. I've handed this honorable court, the Honorable Mr. Kearns, and the prosecution of the Honorable Madam President, District Attorney, 17-16-4B1. It's on page 3 of 5 of the copy I've given the parties. It states the reciprocal discovery, which Mr. Williams did opt into. B1 towards the center but top of the page. It states the defendant, within 10 days of timely compliance by the prosecuting attorney, but no later than 5 days prior to trial, or as otherwise ordered by the court, shall permit the prosecuting attorney at a time agreed to by the parties or as ordered by the honorable court to inspect and copy or photograph books, papers, documents, photographs, tangible objects, audio and videotapes, films and recordings, or copies or portions thereof, and to inspect and photograph buildings and places which are within the possession, custody, or control of the defendant, and this is what I stress, and which the defendant intends to introduce as evidence in the defense's case in chief or rebuttal at trial. I am not in my case in chief. This is the state's case in chief. I'm on cross-examination. On 17-16-7, which is the other copy I've given this honorable court, and the parties, our legislature wrote, no later than 10 days prior to trial or at such time as the court permits, or at the time of any post-indictment pretrial evidentiary hearing other than a bond hearing, the prosecution or the defendant shall produce for the opposing party any statement of any witness that is in the possession, custody, or control of the state or prosecution, or in the possession, custody, or control of the defendant or the defendant's counsel that relates to the subject matter concerning the testimony of the witness that the party in possession, custody, or control, and this is what I stress, Your Honor, of the statement intends to call as a witness at trial or at such post-indictment pretrial evidentiary hearing. I am not the person who intended to call as a witness at trial or any such post-indictment pretrial evidentiary hearing Mr. Bean. The state called him. I don't have to, by law, give anything to the state that I did, and calling a person under the umbrella of the attorney-client privilege and asking to give over information is unethical. When Ms. Love asked me yesterday, I was very polite to her, but I told her I feel like I would be contributing to your unethical and unlawful conduct. I will not speak with you about this. In addition to that, Your Honor, you heard Detective Velasquez testify that he, at times, destroys recordings. I have never heard that before. You heard Detective, who was a female, Benton, say that that is a crime. You heard a witness, Mr. I'll get the name, but he's the one who had the car from his girlfriend, say, Nava Flores, thank you, say that he made a statement to Detective Quinn, and that statement was then erased, deleted, whatever his word is in the transcript. That's what I'm dealing with. And this is all taken together. In addition, if you remember, Mr. Williams is stopped by a police officer, and he testified, I don't know where the video is. It should be there. I don't have the video from anything that is helpful to Mr. Williams. Things that would gotten. I don't have the video in this instant. You would know how many people, the jurors, not you, would know how many people get out of the car. There's a video recording right there. Of course, I don't get that. So my point to this court is for Ms. Love to take me to task and say that I somehow did something untoward is beyond offensive, but I really don't care because it's, you know, I've always learned that you got to listen to who it's being given from. So I don't really care. But what I do care about is we have delayed the trial for Ms. Love. I was cross-examining Mr. Bean last time. I wanted to cross-examine him now. I have every reason. I've impeached him. He said that he did not tell me or Mr. Martin things on that recording. He did not, or he doesn't remember. I've laid the foundation. The Honorable Court wants me to lay the foundation. I laid the foundation. I intend to play the recording with him. I'm also going to play the recording with Mr. Bean and Detective Quinn. Mr. Bean was asked questions by the state of Georgia. They left out all the parts that Mr. Bean admits that he lied on jail calls to his wife. The state didn't ask him about that. I will ask him. And then I plan on playing that recording. It's about 2 hours and 30 minutes. Then I have jail calls that I'm planning to play, where Mr. Bean specifically tells his wife, and he explains it on the recording to me, they gave us a story to tell. He wants to get out of jail. He inserted Jeffery Williams, an innocent man. I'm asking the court, under all these circumstances, to use its discretion, and I would like this court to bar this trial from going forward, because this is what I'm dealing with, and it's not only now. You are going to hear this. I know I did it earlier, but you're going to hear it over and over again. And Ms. Love continues to try to make me some sort of villain. From her opening statement and defies the court order, don't mention that I'm represented anybody, don't mention any appeal. She puts it on the screen. She asked witnesses, did the Honorable Keith Adams or I speak with a witness? That is not bias. That's what we're supposed to do. You would go crazy on me and Attorney Adams if we didn't interview all these witnesses. That's why we take these breaks. Because the state dumped on us all these witnesses in September, October. I need to interview them. I've been doing it. And now I'm being somehow told that that's a bad idea and I have to give the state all my notes and when I met with people and who I met with them with. I'm not doing it. And it's not required by any law. If you notice, the state doesn't cite any law. The state of Georgia also gave me until 2 nights ago at midnight to provide all this information. I ignored that email. The Honorable Court was on it too. I don't know if you read it, but it is obscene. Miss Love is not my boss. I owe nothing except to the law and Mr. Williams. And that's where I am. I am so focused on the law, the court, doing it right, and my zealous advocacy for Mr. Williams. And with all this being said, I don't know how I'm standing here at 2:30 in the afternoon.
It is 3:30, that clock's though.
Okay. All right, 3:30 in the afternoon, and arguing somehow that I'm doing something wrong. I did not hear an apology from District Attorney Love telling the court that I'm not being candid with the court. I don't want her apology, by the way. I wouldn't want it. I don't seek it. But I do want the Brady evidence. I believe that these exist. I believe that there is a memo, a statement, a recording. Nobody goes and talks with Mr. Bean. Why would he say that to the detective 6 days later? And say, I lied to your, whatever it is, coworker. Well, I'm not looking at it right now. I lied to your detective, your coworker, your something. Why would he say that? And why would Detective Quinn say, yeah, all right, well, tell me what you said. What'd you lie about? Detective Quinn wasn't like, what? You were interviewed? I don't have a statement. What are you talking about? But now, of course, I'm stuck with Detective Quinn telling me, no, I don't have anything, Mr. Steele. So my point to you, Your Honor, is this is total misconduct. This is clearly misconduct. And if it's not evident, I have never, maybe the court has, but I have never seen, this is the second time. I don't know if you realize it because it was a pretrial motion. It's the second time that statements, police officers' statements are totally wiped out or changed. It happened with a pretrial, tried to suppress some evidence. Honorable Court denied it. I asked why we have 2 police reports. The officer said, I have no idea.
Is that when we had the hack or something to that effect?
I can't answer that.
Yeah, but I believe that there is some, so there was some discussion at that point in time about
But
that.
this doesn't make sense to me because right at the critical point, I don't know how I got it. I mean, but it was served in discovery, so I appreciate the state doing that. But D, Mr. Williams dated today, right at the critical point of he advised me during on D, Mr. Williams D, it's blank. And then on C, as in Colette or Charlie, he advised that, so it's changed he and 3 other males. All of a sudden, we're right there with 3 other males. I also interviewed Mr. Murphy. He said, I never said there were 3 males in there. Get the recording. But I have nothing. So now I guess Mr. Murphy's lying. So Mr. Bean's a liar and I don't get to present the truth to the jury. Mr. Murphy, I guess, a liar, I don't get to present that to jury. All because district attorney who's employed with the Fulton County District Attorney's Office, District Attorney Love tells me I can't do it and tells this court that I'm manipulating. So I am, I'm outraged. I mean, I've never, as you know, I've never been in court, but this doesn't make sense. And to have a lawyer come up and tell you, Your Honor, how lack of candor I have when District Attorney Love knows all this. This is in her own exhibit that's introduced into evidence on radio traffic. And if she doesn't know it, then say, I don't know the case. I shouldn't be making these representations. And where is the documentation that she had on March 4th telling this honorable court that Mr. Bean never went to a hospital and went right to jail, which concerned this honorable court. And you told me, hey, this is important. You're not going to manipulate anybody. I know you're not going to do it. Figure it out. I know you don't want to play games with the court or whatever your words were. You said all that. I know you wouldn't ever do it on purpose, but I need to know because if he didn't go to the hospital, you're not going to present it, right? And I said, I won't present it. It's true. But it's not accurate. And Ms. Love just walks away without any type of admonition to say, you got to tone it down. This is a trial. Your court called it Battle of the Titans. The Honorable Judge Tom Davis once told me trials are a collision sport. If they don't like what's coming out, that's for a jury to determine. But the rubber has met the road. I am here. I am prepared. I am focused. And I want to go forward. Well, I'd like you to declare that this case should not go forward because I don't understand how I don't have this information. And it doesn't make sense that, oh, no one got the surveillance. Are you joking? Did you see how many police officers are there? There is a recording that you heard. They were looking at the surveillance video. You heard that. Mr. Adams played that. Or the state actually played it. Mr. Adams asked them to play it. But I don't get the surveillance video from September 11, 2013. How is this all just no big deal? I think it's a big deal. And I think that this is an unfair, not you, Your Honor, this is an unfair trial to put this on Mr. Williams 10 years ago, 11 years ago, and the state is not giving me Brady evidence and now trying to thwart a cross-examination. I just, you know, my mother would tell me that I have a lot of nerve if I raise those issues.
Okay. Anything else, sir? I mean, I'm going to make a decision as to the issue of Mr. Bean. But preliminarily, I'll admit Williams, 202-203, the recorded interview of Mr. Bean and Detective Quinn, and Williams C and D under the purposes of
Your Honor, I also have...
One sec, please. In order to make a 103 determination under OCGA 24-1-103.
I also have Mr. Williams B, and it's in Barry Bravo. And that's I know the court said you're looking at, that's an excerpt portion of the proceedings relating to a bench conference during the testimony.
I'm gonna rely upon in fact, I'll ask Miss Weaver to attach the rough transcript as the next court exhibit in order that was prepared by her. It's a lot lengthier and full and describes what happened prior to that than our bench conference. So that'll be the next court exhibit in order.
Okay, and that next court exhibit I was referring to as B, Mr. Williams B.
Okay. I'll just ask Miss Weaver to include that as well. Okay, all right.
Your Honor, I have before for the court's consideration State's Exhibit 1JWM. It is the defendant Jeffery Williams list of witnesses, Your Honor. He lists 28 witnesses by name. His list of witnesses, number 29, states any and all co-defendants in the above referenced indictment, but more importantly, number 30, any and all witnesses named in the state's witness list are on defendant Jeffery Williams' list of witnesses. Adrian Bean is a witness listed on the state's witness list. And since defendant Jeffery Williams has listed Mr. Bean as one of the witnesses he intends to call, the state is entitled any interview of Adrian Bean and is entitled to know how many times, what interviews, what recordings defendant Williams has of interviews with Adrian Bean. That's the first thing.
But that would be in contravention of 1716-4 and 1716-7. I mean, yeah, you're right. You're entitled to them, but it's for his case in chief.
Your Honor, the 1716-7 specifically says any statements of a witness that the defendant intends to call as a witness at trial. And the defendant listed on his list of witnesses that he intends to call.
Okay, but it's not his case yet.
I understand.
And he has no burden to do that. And he may change his mind in that respect. So I'm not even going to consider that until such time as the defendant makes his case in chief. But I agree with you, and I agree with Mr. Steele. It would need to be turned over at that point in time.
Your Honor, additionally, Mr. Steele failed to say to the court, point to the court. Instead, he spit out allegations and insults that were meant to, I suppose, take the place of actual evidence. There is no statement, Your Honor. He pointed to...
No statement of what?
There's no statement made by Adrian Bean at the hospital. I was wondering why he didn't play the interview that he had with Adrian Bean. So at this time, Your Honor, the state tenders for the court's consideration the 10-minute interview that Mr. Steele has.
Can I hijack y'all for just a second? Folks, it's about 3:40 can we, since I don't think we're going to get to our jury today, can I ask them to come back tomorrow?
The state has no objection.
Mr. Steele, anybody? Because it sounds like we haven't done anything. We're not going to, this is going to consume the rest and the residual of the afternoon in Wheeler Parlance terms. All right. Sergeant Ingram, if you could just release our jurors and tell them that we will see them tomorrow. Hold up. Let me give you time. In fact, I'll do it. Just have them come out.
All right, for the jury.
All right, ladies and gentlemen, please be seated. All right, ladies and gentlemen of the jury, good afternoon. Okay, I got good news and I got, not so good news, all right? Which one do you want to hear first? Okay, I like you all. All right. We unfortunately got bogged down with some business that we need to take up outside your presence and hearing. And of course, I told you that happens during trials. And I try and as much as I could, but I failed miserably in that attempt today. So, we're still working. So what I'd like to do is, and here's, I guess, where the good portion comes in. I'm just going to recess it for today, okay? And have you come back in the morning. If you could be here tomorrow morning for as close to 8:30 as you can. We'll start probably a little after 9 o'clock, and then we'll probably go to a little after the noontime hour, and then we will be complete for tomorrow. Does that work for you all? Okay. Any minister or inquiry of me? Okay. Thank you again. Thank you for your patience with us. We appreciate it. We know these kind of things happen, and I told you they would happen. And I tried as much as I can not have you waiting on us. So please accept our apologies, or my apologies, on behalf of everybody, okay? All right, ladies and gentlemen, unless you have any other inquiry of me, leave your notepads in the basket. Remember the admonitions I've given you. Don't discuss any of the matter that we have covered up to this point in time. Do not review any news accounts or any other recaps of what may or may not have happened in court. Of course, you can only consider what's in the four walls and presented to you in lawful form inside this courtroom. If anybody should try and talk with you about this case, remember your duty to let myself and Sergeant Ingram know immediately. Don't go by and visit any scenes. Don't go by and have any outside conversations in regards to anything you may have heard inside or outside this courtroom, okay? And of course, don't listen to any news media accounts about the trial like you've done so far. So, ladies and gentlemen, unless you have any other questions of me, I'm going to go ahead and release you for the day. I'll see you in the morning, okay? For 8:30, all right? All rise. All right, ladies and gentlemen, please be seated. Our jury has left us.
Your Honor, could we get a public break and then opportune time?
You've asked for a lot today, you know that? So, you should be happy with where you are at this point in time in the afternoon.
Thrilled.
Right? Okay. Oh, and by the way, you need to have your order done to me by the 29th since you volunteered to speak up. And yes, I will give you a comfort break.
Thank you.
How about we take councils to 4 o'clock? Does that work for you all? Miss Hilton, since you already had a break, you need to sit down here for the next 15 minutes in timeout. Okay, but everybody else, let's just come back at 4 o'clock, okay? All right, and we'll finish up for at least this issue. All right, we're in recess until 4.